Are we all ready? Yeah. Okay. Before we begin, I would like to remind our spectators that their microphones should remain off at all times. For judges and participants, please keep your cameras on and microphones should be on mute when not speaking. This is the Dr. S. Glazer courtroom. All present. Session W3 of the Walker Moot Supreme Court is now in session. It is with great honor and privilege I present Justice Lindsay Charles of McLeish, Orlando, Nick Todorovich of McLeish, Orlando, Samantha Delfrati of formerly McCarthy Tachar, Gabriella Aber of DDS Student Presiding. Justices of the panel, I present to you speaking on behalf of the appellant, Ms. Armstrong, in today's matters before the court. Haley, Berge, and Alexia Donis. And speaking on behalf of the respondent, Dr. Ward, Wafa Khan, and Nikolai Bola. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent's counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to this court, including answering questions from the bench. The appellants will present their arguments first, followed by the respondents, then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there is 5 minutes left per speaker. Appellants, will you be using your 3 minutes rebuttal?
We have not decided yet. Do we need to provide an answer right away?
I think you should, because that will.
I think it's fine for them to wait.
Okay, that's fine then. Okay, the court now invites counsel for the appellant to begin.
Good afternoon, justices of the court. My name is Alexia Donis. I, along with my co-counsel Haley Berge, are representing the appellant, Ms. Armstrong. Today, I will be talking about the standard of care for medical negligence in Canada as applicable to this case. I will also discuss the appropriate standard of review on the appellate level. My co-counsel Haley will be addressing factual causation and the burden regarding non-negligent causes. Now, if the justices would like, I am happy to present a quick statement of facts.
I would go ahead.
Okay. Dr. Colin Ward removed Ms. Karen Armstrong's colon using laparoscopic procedure. He performed this colectomy using a device known as a ligature. A ligature is widely used in surgery to seal blood vessels via electrical current. There's a side effect to using this device. The ligature can cause damage to tissues within 2 millimeters of its jaw through thermal spread. This was a routine procedure. Ms. Armstrong was anatomically normal. Dr. Ward completed the surgery. Post-operation, Ms. Armstrong's utera became blocked, which led to the loss of her kidney. At trial, the judge found that Ms. Armstrong suffered this injury due to negligence on the part of Dr. Ward. He accepted that Dr. Ward used the ligature within 2 millimeters of the ureter. This is an issue of fact, which is not on appeal today. The issue here for the court to consider is whether the trial judge correctly applied the standard of care. Now, standard of care is an individual element of the general negligence test. So let's break down negligence, as outlined in Deloitte and Livent. Negligence includes an owed duty of care, a breach of the standard of care, and damages caused in fact and in law by this breach. According to Critz and Sylvester, in Canada, the standard for medical negligence is outlined as follows. Every medical practitioner must demonstrate a reasonable degree of skill and knowledge and must exercise a reasonable degree of care, which could be expected of a normal, prudent practitioner of the same experience or standing. For this case, the trial judge correctly applied the standard of care. He noted that the standard of care for a general surgeon performing laparoscopic surgery as identifying, protecting, and avoiding direct contact or close proximity to the ureter when using a ligature. Therefore, breaching the standard of care would be to touch the ureter or come within close proximity of it during a routine colectomy on a benign colon. Now, my friends rely on Critz to mitigate the fact that although the outcome of the surgery was not perfect, Dr. Ward's only obligation was to exercise a reasonable degree of care and skill. However, Critz elaborates this care and skill must also be demonstrated in comparison to a normal, prudent practitioner of the same experience or standing. All of the expert witnesses at trial agreed that a general surgeon must take steps to identify, protect, and avoid contact or close proximity to the ureter, as outlined by the trial judge. The experts described close proximity as within 1 or 2 millimeters of the ureter. At trial, Dr. Ward even agreed that a surgeon must dissect far enough away from important structures to avoid damaging them by thermal damage. So it is not disputed that these are the steps that should be taken. The dispute is that the majority at the appellate court was content with Dr. Ward meeting some of these steps, not all of them. And the trial judge required all of the steps be met for the standard of care. Dr. Ward did not meet the final step of staying away from the ureter, so the trial judge correctly noted this as a breach of the standard of care. And we are not here to argue about a perfect outcome. This is not on the table today. We are here to discuss the appropriate steps that a reasonable or competent surgeon should take. This is a standard of reasonableness, void of perfection. Simply, Dr. Ward did not take all of the necessary steps. Now, the goal of the surgery was to remove the colon. My friends raised that the trial judge falsely relied on the goal of not injuring the ureter, which would focus on results and perfection. They preferred to categorize it as a step. That's fine. The controversy between goals and steps is simply semantics. You can break down any surgery, any goal into steps. The goal was to perform the procedure properly. In order to do this, you must follow necessary steps, like staying 2 millimeters away from the ureter. Let's say a surgeon is performing a tonsillectomy on me. The goal is to remove my tonsils. My surgeon successfully removes them, but knocked out some of my teeth in the process. Has the standard of care been met? While my surgeon met the goal of removing my tonsils, the standard of care is not entirely fixated on this. My surgeon did not take all of the necessary steps to protect my mouth, just like Dr. Ward did not take all of the necessary steps to identify, protect, and stay away from the ureter. The standard of care is based on the means, the conduct of the surgeon. Dr. Ward completed the surgery, but it was performed negligently. Now, I would like to turn the court's attention to the issue of standard of review. For the standard of review, the appellate court inappropriately applied a correctness standard of review. While this standard is utilized to review questions of law, like the articulation of the standard of care, it is not used to determine whether this standard was met. That is a question of mixed law and fact. Review of fact only pertains to palpable and overriding error. This examines whether the trial judge was clearly wrong, which is palpable, in a manner that has an effect on their decision, which is overriding. Now, negligence and causation, as we are talking today about it, are matters of fact. Since there was no palpable or overriding error, deference must be afforded to the trial judge when considering the factual instances of the standard of care. At the end of the day, the trial judge outlined the standard of care as identifying, protecting, and staying away from the ureter. All of the experts on trial agreed that these are crucial steps. We aren't arguing here about a perfect result or outcome. We are simply saying that there are things you should do and you shouldn't do. You should remove the colon. Let's call it a goal. And you shouldn't injure the surrounding organs by adhering to careful conduct. And sure, let's call it steps. These are instances influenced by fact, which affords deference to the trial judge. Since there was no palpable or overriding error, the reasoning should not be disputed. Now, my co-counsel Haley will discuss factual causation and non-negligent causes. And I would like to thank you, justices, for your time today.
Sorry, counsel, I do have a question for you. So is your position saying that there can never be a situation that allows for any room of error? So there is no reason that he should have come within 2 millimeters that was not negligent?
So we aren't exactly talking about zero risk here or perfect outcome, perfection, absolutism. This is a standard based on reasonableness. And as Kritz outlines, this reasonableness is based on reasonable care and skill of a prudent surgeon of like experience and standing. So we have to base conduct on that. So we see at the trial, all these experts of like experience and standing saying, this is what is reasonably expected to do. You identify and protect the ureter. How do you do that? By avoiding close proximity or direct contact. Does that answer the justice's question?
Yes, thank you.
So if the justices do not have any further questions, I would like to introduce my co-counsel, Haley Berge.
Thank you, Alexia, and thank you for your time today, justices. So as my co-counsel said, my name is Haley Berge, and I will begin by picking up where Alexia left off. So I think it is worth restating that the trial judge's opinion is entitled to deference. I would also like to point out right away that we are not discussing issues of dexterity or camera magnification issues, nor are we weighing the expert witnesses' opinions against each other. Instead, the issue that we are discussing today is whether or not the trial judge was incorrect in bringing factual causation to assess whether the standard of care was breached. So at the Court of Appeal, the majority maintained that the trial judge erred by conflating the standard of care with causation. They argued that the issue of causation should be addressed only after the trial judge has determined if the defendant has breached the standard of care or not. It was stated that to do so amounted to an outcome-oriented approach or backwards reasoning. While in general, we do accept that it is true that the issue of factual causation arises after the trier of fact has found that the defendant breached the standard of care, there are, however, cases, such as the one at bar, which require the factual causation to be determined in order to decide whether the standard of care has been breached. So after we've determined what happened, then it can be decided whether or not that conduct in question falls below the standard of care or not. So in this case, the trial judge made the finding that Ms. Armstrong's injuries were caused by the thermal spread of the ligature before he concluded that Dr. Ward breached the standard of care by operating within 1 to 2 millimeters of the ureter. Doing so was not a mistake. Again, we submit that the trial judge did not err by determining factual causation of the injury before concluding that Dr. Ward breached the standard of care. In fact, in certain circumstances such as this one, it can be considered essential that the trial judge makes a determination of the factual cause of the injury before turning to the standard of care assessment. This issue was addressed in Grasson Women's Hospital, and it was later clarified in Leone and Peters, where the court stated that while it is not a steadfast requirement, it is sometimes preferable to determine factual causation prior to determining if there was a breach of the standard of care. Because of this, we think that the dissenting opinion of Justice Rendsburg should be followed. The trial judge determined both the causation and the standard of care by relying on the strong expert evidence that was presented at trial. It was stated on appeal that there was little difference between the standard of care evidence of the experts. Ultimately, the trial judge accepted Dr. Bernstein's evidence that Dr. Ward came within 1 to 2 millimeters of the ureter during the operation, which resulted in scarring, a blockage, and ultimately the removal of Ms. Armstrong's kidney. Having strong and consistent evidence at trial is important in determining the factual cause of the injury. And if the plaintiff's injury provides sufficient circumstantial evidence to allow the trier of fact to infer a breach of the standard of care, then this is acceptable. In this case, Ms. Armstrong's injuries provide sufficient circumstantial evidence. And again, I would like to remind the court today that the trial judge's opinion, in fact, is owed deference and that we are not disputing such issues of fact today. I would now like to turn the court's attention to the issue of whether or not the plaintiff is obliged to rule out non-negligent causes. So in a medical malpractice case, the plaintiff is not required to disprove all possible non-negligent causes. In particular, there is no onus on the plaintiff to disprove theories that are only raised on appeal and not at trial. The majority stated that it was an error to not address various non-negligent causes such as dexterity issues, camera issues, or periodic vermiculation unexpectedly causing strictures to move during surgery. However, it is well understood that during a trial, parties must present their best evidence and advance their strongest arguments to support their cases. What is not advanced at trial does not need to be considered by the trial judge, nor does the plaintiff bear any onus to disprove evidence that is not called at trial. The Court of Appeal noted that it is trite law that a trial judge must decide a case on the evidence and only on the evidence raised at trial. Because of this, it is submitted that the trial judge did not err by not considering other non-negligent causes. Additionally, it is submitted with the same logic that the plaintiff also has no responsibility to disprove non-negligent causes. In fact, considering outside evidence would have been considered a judicial error. For example, there was no evidence raised which theorized that Dr. Ward was physically pushed in the middle of surgery or that there was an earthquake that caused injury to the ureter. It would therefore be inappropriate and unnecessary for the plaintiff to lead evidence to try and disprove that Dr. Ward had not been physically pushed or that there had not been an earthquake during surgery. If a non-negligent cause is not raised as evidence at trial, then the trial judge need not consider it. In Hassan and Anvari, it was said that a trial is not intended to be a scientific exploration with the presiding judge assuming the role of research director. It is a forum established for the purpose of providing justice for the litigants. As well, I think that it is important to note before the court today that the trial judge actually did address the potential non-negligent causes that were raised at trial, and then he rejected them. In his testimony, Dr. Ward maintained that he stayed 5 to 10 centimeters away from the ureter during the entire procedure. And because of this, he then theorized that his use of the ligature several centimeters away from the ureter was what caused the damage. No other non-negligent causes besides this one were raised at trial by the respondent. If the respondent wished to raise issues such as dexterity, camera magnification, or unexpected movement of strictures during surgery, then he should have done so at trial. The same logic applies to the plaintiff. There is no onus on the plaintiff to disprove non-negligent causes. So this concludes the appellant's position. Thank you very much for your time today, justices, and I welcome any questions that you have at this time.
Are there any questions from any of the justices? No. Lindsay, you're on mute if you're trying to.
Sorry. Thank you for your submissions. I guess we're just wondering, is this something where it's just beyond the control of Dr. Ward, and how do you kind of address that? I know you did kind of explain, if an earthquake happened or something like that, but I'm assuming when you get in there, is what happens in that kind of circumstance?
I can address this question. Thank you very much, Justice, for asking. So as I was discussing the non-negligent causes, I'm guessing that you're asking if there was something else that could have happened that was simply beyond Dr. Ward's control. And to respond to that, I would like to bring you back to what my co-counsel was discussing, that this surgery was considered surgery 101, that the expert witnesses testified that there was no reason for Dr. Ward to have caused the injury through non-negligent causes, and then that the evidence that was presented that he'd had come within 2 millimeters of the ureter was accepted by the trial judge, and therefore that factual finding is owed deference. So, and particularly, I would like to add that since Ms. Armstrong's colon was anatomically normal, it was benign, there was no inflammation or anything else that might be common in a colectomy. It was essentially like working on a blank canvas or sailing on calm seas versus riding into a storm, if that answers your question, Justice.
It does now. And in the event that there were other conditions or problems with the colon, would that change your position?
If there had been other issues, by which I'm assuming you mean something that is not anatomically normal or a non-benign colon, that would have to be analyzed on the basis of the facts of that procedure. So again, in this procedure, since it was anatomically normal, if there was some other non-negligent issue, then Dr. Ward bore the onus of raising that at trial, which the non-negligent cause he did raise was rejected by the trial judge, and therefore no further non-negligent issues can be raised at this stage.
Thank you, counsel.
Do any of the justices have other questions? No? The court now invites the respondents to begin.
Thank you. Good afternoon, justices, colleagues, friends, and family. My name is Bola, and along with my co-counsel, Wafa Khan, we are here today on behalf of the respondent, Dr. Colin Ward. My colleague and I will be addressing three main points to the court today. I will address the issues of causation, which in my submission simultaneously touches on non-negligent causes. Following that, my colleague will address the standard of care and the standard of review. My submissions will consist of two key points. First, that the trial judge improperly concluded that the injury to the ureter was a result of negligence by utilizing causation as circumstantial evidence. And second, that the trial judge did not consider a second and likely potential cause of the resulting injury. My first point, that the trial judge improperly concluded the injury to the ureter was a result of negligence by utilizing causation as circumstantial evidence. Within the definition of the standard of care relied on by the trial judge was an error of law, and causation should not have been used to define the standard of care in this case, because the generally accepted law in Canada is for the court to first determine what the requisite standard of care is, and then determine causation. As reiterated by the Court of Appeal, in some instances where the finding of causation is essential to determining the standard of care, on a case-by-case basis, it may not be an error of law to do so. The appellants rely on the instances when the court does accept the causation in fact prior to determining the breach of the standard of care. For example, they reference the Grass v. Women's, where the judge concluded that determining causation was essential to informing the standard of care because there was no other possible explanation to causation other than the negligent act. This differs from this case because there were other possible unexplained non-negligent acts. In this case, the court would need to rely on the trial judge's inference of causation to consider this reasoning to be correct in law. There must be no other explanation than Dr. Ward coming within 1 to 2 millimeters of the ureter with the ligature, causing the thermal damage directly to the ureter. This is flawed reasoning because it was clearly stated by the Court of Appeal that the trial judge did not make any findings of fact, that the only possible way the ligature could come within 1 to 2 millimeters of the ureter is by that negligent act. Accepting the appellant's reasoning of the trial judge correctly utilizing causation to inform breach of standard is by accepting the trial judge's finding of causation is in fact based on that act. Additionally, if a trial judge is prepared to move forward with the mindset that the only possible cause of injury is by a negligent act, then that judge has an obligation to consider and rule out non-negligent causes. Here, the trial judge concluded there was a negligent act, but failed to rule out the other non-negligent causes. In this case, the respondent respectfully puts to the court that the trial judge did not fulfill his obligation to consider, explore, expand, and rule out all non-negligent causes brought forward at trial. Specifically, a second and likely scenario advanced by the plaintiff's expert, Dr. Klotz. He offered a second suggestion that another likely cause of the injury was thermal damage to the surrounding blood supply of the ureter. Which brings me to my next point, that the trial judge erred by not considering the second and likely potential cause of the resulting injury. Within the definition of the standard of care set out by the trial judge in this case, Dr. Ward would likely have been exonerated from liability if it was found that the injury to the blood supply, that the injury was to the blood supply and not to the ureter, because the distance between the ureter and the ligature would have been more than 1 to 2 millimeters. Time permitting, I will utilize the diagrams found in Appendix A of the respondent's factum to illustrate the approximate distance between the blood supply and the ureter, to further show the court that this scenario is probable and should have been explored. I would like to draw the court's attention to the trial judgment at para 97. Here, Dr. Klotz stated, and I quote, "The likelihood is that it was a thermal injury either to the blood supply or to the ureter itself." Dr. Klotz proposed two distinct scenarios here. He singled out the ureter by adding the word itself after, implying that his second suggestion of damage to the blood supply was a separate and likely cause of the damage to the ureter. This was not considered by the trial judge. Dr. Klotz continued to explain to the court the reasons in which he personally believed that the thermal damage to the ureter was the correct version of events, which was accepted by the trial judge. However, he failed to explain to the court why the second likely scenario he had just mentioned was seconds later not likely at all. If the blood supply was not a likely possibility, it's unclear why the expert witness would suggest this other scenario. And with respect, this is the precise reason that the blood supply scenario needed to be explored by the trial judge to get all the experts' opinions on the subject, and additionally, for the trial judge to have the sufficient evidence needed to determine the what happened in order to determine negligence. Here, the trial judge determined the negligent act was coming within 1 to 2 millimeters of the ureter with the ligature. He should have asked how many millimeters away from the blood supply would constitute negligence. And if the damage was to the blood supply, was Dr. Ward more than 1 to 2 millimeters away from the ureter? These are a few examples of questions that the trial judge had an obligation to explore and rule out, but did not. If he had considered this scenario, the court would have been presented with expert evidence suggesting that at least 3 points of contact with the blood supply surrounding the ureter would be possible. The trial judge relied on the importance of consistent expert evidence. However, the amount of consistency measured by the court was only relevant to one of the two scenarios. Dr. Bernstein and Dr. Klotz's expert evidence was consistent with the theory of damage occurring to the ureter. Had the damage to the blood supply been considered, the expert testimony of Dr. Robinette and Dr. Hagen would have been consistent in supporting that theory. Dr. Robinette testified that scarring, adhesion, and fibrosis observed by Dr. Hartsberg could happen even if the ligature was used more than 1 to 2 millimeters away. His opinion that the damage was not caused directly to the ureter because if it had been, Ms. Armstrong's symptoms would have been prominent within days. In this case, it took 21 days for Ms. Armstrong to express discomfort and approximately 2.5 months to develop prominent issues. Dr. Klotz then supported this theory by stating that an inflammatory response could also lead to scar tissue eventually developing in the surrounding areas of the damage. With this expert testimony, if the thermal damage to the blood supply and the scarring, adhesions, or inflammation of the surrounding tissue, developed, then it could cause the same outcome at a slower pace. This is consistent with the development of Ms. Armstrong's symptoms, and by extension could have put the ligature device more than 1 to 2 millimeters from the ureter based on the location of the blood supply. If I could have the justices please turn to figure 3 of Appendix A of the respondent's factum for reference. Dr. Hartsberg documented injecting dye through the nephrostomy tube, which is placed in the kidney. He concluded that the dye did not get past about the proximal 1/3 of the ureter. So if you reference this figure, you can visualize where Dr. Hartsberg injected the dye at the top of the kidney, which then flows down the ureter and at about 1/3 down from the top, the dye stops and the obstruction starts. There are 3 pieces of evidence suggesting that it could have been concluded at trial that Dr. Ward did not come within 1 to 2 millimeters of the ureter, but possibly came within 1 to 2 millimeters of the corresponding blood supply. This includes the documented notes by Dr. Hartsburg I just mentioned, Dr. Robinette's opinion that he does not believe the damage was directly caused to the ureter, and Dr. Klotz suggesting this possible scenario. Considering the above, there exists a possibility that Dr. Ward was more than 1 to 2 millimeters away from the ureter, and the damage was, and that the damage occurred via the blood supply. All of the above demonstrates that causation should not be used as circumstantial evidence to inform the standard of care in this case. Barring any questions, that is my submission. I will pass it over to my colleague, and I appreciate your time. Thank you, Justices.
Are there any questions from the justices?
I guess what I'm wondering is the actual outcome of what happened, can that actually impact the standard of care in any way in your view?
Well, like I mentioned, in some instances, the courts do accept the causation in fact prior. So, specifically in Grass v. Women's, in which the appellant mentioned, in that case, the only possible outcome was the negligent act by the doctor, given the surrounding facts of what was happening. The doctor in that case was utilizing clamps to remove the baby during pregnancy, and there was no other factors in that instance. So in a case like that, then yes, it would be necessary to infer such. But in a case like this, there was other possibilities that weren't explored and could have determined the outcome. Does that answer your question?
Thank you.
Thank you.
I have a quick question for you, counsel. So is the standard of care to avoid injury, or is the standard of care to avoid coming within 2 millimeters of the ureter?
In this case, the trial judge determined that the standard of care was staying more than, or not, not coming within 1 to 2 millimeters of the ureter, which is why, that second scenario in which I'm suggesting should have been explored by the trial judge, because at that point, then deference would have been given to, or should have been given to, the trial judge, because he would have had all of the evidence in front of him to make the determination in which scenario was more likely to have happened.
Thank you.
If there are no further questions, counsel, you may begin.
Thank you. Good afternoon, Justices. My name is Wafa Khan, and I will be making 2 submissions today on behalf of the respondent, Dr. Ward. My 2 submissions will be as follows. Number 1, the standard of care of medical negligence in Canada as it applies to this case is one of reasonableness. And number 2, the Court of Appeal did not err in applying a correctness standard of review. To begin, we submit that the requisite standard of care of medical negligence in Canada as applies to this case is one of reasonableness. What the trial judge was proposing as the definition of the standard of care was based on perfection. We would be doing a disservice to 65 years of medical negligence history if we alter the standard of care from one of reasonableness to one of perfection. And this was established in the well-known case of Kritz and Sylvester. What the trial judge suggested by his finding was using the end outcome of a surgery, which is a goal a physician has, to define the standard of care. And this suggested standard imposes a strict duty of perfection on surgeons expecting a perfect outcome every time, and that is simply not reasonable. A physician's obligation is to exercise a reasonable degree of care and skill in the steps that they take to perform a procedure, and they should not be judged by the outcome of the procedure. An injury to the ureter does not mean that Dr. Ward did not follow the steps of the procedure, and this takes into consideration other alternative factors that could have impacted the procedure. But if we are to accept the trial judge's definition, we are incorrectly concluding that an injury to the ureter means that Dr. Ward was negligent, even if he did follow the steps. And by asserting this standard of perfection, we are suggesting that avoiding the injury constitutes the standard of perfection, and that's going to create absolute or strict liability. And this is, again, very unreasonable on medical professionals. This is going to fail to consider other accidents or non-negligent causes that may have affected the ureter. And this brings me to another key point about the standard of care and why it should be one of reasonableness and not perfection. To accept this heightened standard of care creates a very dangerous precedent for the world of medical negligence because it imposes strict or absolute liability on healthcare professionals. In the case of Kritz and Sylvester, it was stated, and I quote, "But we should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than of the good of their patients. Initiative would be stifled and confidence shaken." If the court here today accepts the standard of care definition that was applied by the trial judge, we would be responsible for the collapse of our healthcare system. We would be responsible for imposing absolute or strict liability on healthcare professionals who are performing this surgery or even any similar surgeries. And by suggesting that this is indeed a case where causation can be determined before standard of care to define it, sets a dangerous precedent in the world of medical malpractice. Future courts will turn to this case we are arguing before you justices today to justify applying this incorrect standard of care. And this is going to alter the fundamentals of the physician-patient relationship. Our healthcare system would be overflowing with patients in need of life-saving surgeries, but with no physicians available to perform these surgeries because of the imposed liability. And even for surgeons that are willing to perform these surgeries, we can expect poor access to timely healthcare. Residents of Canada are already experiencing extensive wait times to see specialists and to undergo necessary surgeries. But to impose an even longer wait time due to no physician being available because of no one being able to do this procedure, and they're not opting to do this procedure, the trust that society has in our legal system would be completely decimated because this court here would be responsible for imposing this hardship on them. Not to mention that these physicians are going to be performing intricate surgeries under emotional, mental, and physical stress, which could actually lead to more accidents. But by the trial judge's definition, this is just going to mean it's negligent behavior. So as you can see, there is no way for physicians to uphold their sacred oath and perform their duties without a fear of severe repercussions if anything was to prevent a surgery from being successful, including an accident or non-negligent causes like a pre-existing medical condition. The trial judge also fails to consider accidental acts or omissions that could have resulted in the ureter injury, which was just briefly elaborated on by my co-counsel. One of these accidental acts would be an error in judgment. If the court refuses to believe the alternative causation theory that was just elaborated on by my co-counsel and does accept that Dr. Ward came within 1 to 2 millimeters of the ureter, then he cannot be held liable for an error of judgment. As I have alluded to in our written submissions, there are two possible scenarios that could have caused an error in judgment. Number one, Dr. Ward, while he was truly believing that he was 5 to 15 centimeters away from the ureter at all times, while the ureter was off screen, may have accidentally contacted it. And number two, Dr. Ward was utilizing a magnification screen during the procedure. While it was not submitted at trial what the magnification actually was while this procedure was being undertaken, it is very possible that the distance that he had in his mind was not to scale and did not translate properly onto the magnification screen. So as you can see, these are two situations that exhibit accidents due to an error in judgment, and they should be void of liability. The standard of care is about reasonableness and whether or not the physician was reasonable in taking steps required of them. It's not about whether a physician took some steps and decided not to take any others. What is required for a physician is to demonstrate that they take every step and that they are as reasonable as expected. And the key word is reasonable. They do not have to be perfect every time, and they don't have to be successful as long as they are reasonable. And when a surgeon undertakes a procedure, they do have more than one goal, such as making sure the procedure is completed before anesthesia wears off, making sure that they can identify and try to protect major organs and organ systems, and even just completing the procedure itself. So to hold them to an impossibly perfect standard with guaranteed liability is simply wrong. Binding Supreme Court authorities of Keith and Abraham, Caven and Wilcox, and the Ontario Court of Appeal case of Kurtz and Sylvester all say the same thing. We should not judge a physician by the end result of a procedure. Accidents do occur, and they do not mean a physician was negligent. Misadventures and unfortunate outcomes do occur during the course of procedures, but that does not mean a physician was negligent. And this is precisely why it's mentioned that the rate of injury is somewhere between 0.15% to 0.66%. By accepting the trial judge's definition and application of the standard of care, we would be going against what each of these authorities is saying. I will now turn over to my second submission. We submit that the standard of review of correctness as applied by the Court of Appeal was justified because this was a question of law. It was not a question of fact, nor was it a question of mixed law and fact. The trial judge had incorrectly defined and applied the standard of care, and the Court of Appeal was right to correct this mistake. The standard of care that the trial judge was imposing was one of perfectness, as I have just alluded to. The Court of Appeal even confirms that using outcomes or goals as the standard of care is indeed an error of law. The Supreme Court of Canada in the 2002 case of Housen and Nicolaisen says that where there is an erroneous finding of the trial judge that can be traced to his or her characterization of the legal standard, then this encroaches on the lawmaking authority of the appellate courts and less deference is required, consistent with the correctness standard of review. We submit that the trial judge's characterization of the standard of care was incorrect, as was its application. Thus, this is an error of law. The court further states in the case of Housen that there are two reasons why a correctness standard of review applies. Number one is to ensure that the same legal rules apply in similar situations to maintain the integrity of the law. And number two, to recognize the lawmaking authorities of the appellate courts. If we are to assume that the trial judge was correct and a goal should have been used as a step in determining the standard of care, this would ultimately have created disorder in administering justice in medical negligence cases. This heightened standard of care would make the law uncertain, and the courts may have to consider applying this standard of care to similar surgeries and suggest that end goals are part of the steps of a procedure. The Court of Appeal is tasked with making just and practical rules and to refine legal rules coming out of trial courts so that they can be applied universally. It is clear here that the Court of Appeal was doing what was expected of them. They were reviewing and refining the standard of care imposed to ensure that it's universally applicable. And this is a question of law because the issue here is what the correct legal standard is. Right now, we're not concerned with what the facts are between the parties or how the facts apply to the standard of care. Because without first establishing what the correct standard of care is, we cannot judge if it's being applied properly. And we do not disagree that trial judges are triers of fact or that they are integral to our legal system. Rather, what we are saying is that we need to be cautious about what legal rules are coming out of trial courts, and we should be allowing the Court of Appeal to do its job in refining these legal rules. At the end of the day, the goal is to make sure that our legal system is consistent, it's universal, and it's something that the public can maintain confidence in. Justices, for the reasons listed by my co-counsel and I, the respondents submit that this court dismiss the appeal with costs. Thank you.
Hi, counsel. I have a question for you. So someone with experience or a physician or a resident using such an instrument to perform the procedure and knowing the magnification that's involved as it magnifies the adjacent structures in the field and not just the 2 millimeters, there's quite a big discrepancy between 2 millimeters and 5 to 15 centimeters. So how do you account for such a large difference between the two values?
So what we were submitting is that even if the screen was magnifying the organs at the time, it's very possible that what he believed, if he was maybe 5 centimeters away, may not have translated depending on the magnification, because a 20 times magnification is quite different from a 10 times magnification. So based on, of course, this is something that we don't have information on, was what the magnification was, but we were just submitting that this is a possibility of another accident that could have occurred.
But don't you think that it would also magnify the adjacent structures as well, leading to know that 2 millimeters is still magnified to the same extent as something else, regardless of what the magnification is? It's all relative.
Well, while that's true, I do agree with you that all of the adjacent structures would also be magnified. It's more of a situation of having the scale in your mind not completely translating accurately to what's on screen. So what in his mind might have been 2 millimeters or 3 millimeters, he might have mistranslated that while it was being magnified.
Thank you.
If there are no further questions, appellant, will you be using your 3-minute rebuttal?
Yes, we would like to rebut.
Okay. The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Justices, when we are talking about causation, we cannot talk about what should have been explored or possibilities. That is not at issue here today. Considering new information is a judicial error at this level. We cannot talk about blood supply if this was not brought up at trial, or magnification. And consistency is not an issue here either. Disputing the testimonies of the experts is not on appeal today. This is a mischaracterization of the evidence at trial and the trial judge's reasoning. We cannot unfairly duplicate the trial right now. In terms of the standard of care, as I stated, we are not here to argue about a perfect outcome. We are here to discuss the appropriate steps that a reasonable or competent surgeon should take. Dr. Ward himself admitted at trial that if he did come within 1 to 2 millimeters of the ureter, it would be an error. If it is an error, I think we can conclude that it is a step that should be followed. And if we're going to talk about creating a dangerous standard, neglecting the trial judge's findings of facts robs the trial judge of his fundamental role. The experts are not here today. We cannot redo the trial right before your eyes. This would render our trial courts useless, which would create an extreme barrier to access to justice. And since factual causation is an issue of fact, and the negligence element regarding standard of care is a factual issue, the only standard of review is one of palpable and overriding error, and that is not submitted here today. So, justices, I would like to thank you for your time, and the appellant now rests.
Thank you. This concludes the matter of Armstrong and Ward. We invite everyone to join us tomorrow at the next sessions, and it will be starting at 8:30 a.m.